Yes.
It please the Court, my aim still remains to get through the remainder of the valuation grounds 1 to 3 by the close of today and be able to deal with ground 4 tomorrow morning and have sufficient time for a reply Wednesday. We are now in ground 1A, the challenge to the Court of Appeal's proposition that the right approach, in their words, for a court, rate-setting court, is to find individual licenses, one or more, to serve as close parallels or best comparables or true comparables to what you are valuing, said to have its origin as a principle in the case that's called cimetidine, Court of Appeal. The first point I was addressing was the point suggested by Optis that this was an issue of common ground, that this is the right approach. It is one of the areas, they say, of common ground where the judge defied the parties and took his own course. Before the short adjournment, I showed you one paragraph, 2291, in the judgment of the judge, in which he makes clear that it was not common ground in what he says, and that neither side took this to be the right approach. I was then going to, and I will now, show you how Optis approached this at trial. If you would please go in the bundle to page 1294. These are Optis's closing submissions for the trial. You have at the top of the page...
Sorry, could you give me that page again?
Yes, I'm sorry. 1294.
Thank you.
You will see at the top of the page, they are dealing here with valuation methods overview. Underneath that, in paragraph 272, they set out what they say are 3 types of methodology under debate. The first of those is an approach of working out the overall size of the patent stack, patents that accumulate together for all of the 4G standard here, or the pie, as they call it, and then getting to Optis's share of the pie. The second, at letter B, is a comparables approach. If you go on to the following page, 1295, near the foot of the page, you see the heading top-down valuation, which is the approach of working out a pie, an overall amount that you would pay for your licensing to this technology, and then allocating a piece to Optis. And then if you go to page 1304, you have a heading above paragraph 296. This refers to working out aggregate royalties from some of Apple's licenses, based on the Apple licenses. And then at paragraphs 296 and 297 below the title, they refer to Apple's case that one can take its licenses, the collectivity of them, covering a large share of the stack, and they engage with that methodology. At the top of page 1305, the next page, in the first sentence of paragraph 299, they consider, if you go this way, you must add into the pie one of the Apple licenses that had been excluded by Apple as anomalous, and then in their own words, second line, working out the pie implied by all of Apple's licenses. I won't go into this in further detail, but you see clearly that there was no common ground, that there was, as the Court of Appeal has said, the right approach based on cimetidine, involving selecting individual comparables that are seen to be in their own right the most useful guide. Nor, more fundamentally, which I must now address, is it correct that cimetidine itself sets down a right legal approach of how to use individual comparables to do evaluation in any field. On the contrary, our submission is that in that case, the Court of Appeal, Lords Justice Lloyd and Nichols, were clear about two things. One, it is for the judge alone to decide whether there are close comparables to the licence which the court has to determine as a matter of his or her factual evaluation. And their decision can be impugned only if it's wholly unreasonable on appeal. The approaches, second, point two, the approaches referred to in cimetidine, they are only aids to a judge's evaluation. There is no requisite legal approach. If you would please turn up cimetidine, you find it at page 3081 of the bundle. And please would you go in it to page 3114. Foot of the page, there is a heading, comparable royalties, if you see that. And this is Lord Justice Lloyd. And if I read what he says, for my part, I have no doubt that where close comparables exist, they provide by far the best and surest approach. There is no better guide to what a willing licensor and willing licensee would agree than what other licensors and licensees have in fact agreed in comparable cases. Whether a case is comparable or not is, of course, a pure question of fact for the decision of the controller of patents. He and his superintending examiners have unrivaled experience of such matters, so forth. This court has no such experience. In any event, since comparability is a question of fact, we would not be entitled to disagree with the view formed by the Patents Court on such a question, unless that view were perverse, unsupported by any evidence, or so outrageous that no reasonable court could entertain it. And then the other reference, page 3128, within the case. This is the judgment of Lord Justice Nichols. And I draw your attention to the penultimate paragraph near the foot of the page, which begins likewise. Likewise, it says, with the section 41 calculations and the profits available calculation, which I'll come. And then he says this, as with the comparables, these calculations are no more than aids, which may afford valuable assistance in a particular case in carrying out the difficult and imprecise exercise of identifying what sum would be reasonable remuneration in the case. To give assistance, those calculations must be sensible and coherent, but they are only aids and were never intended to be more than that. The calculations are to be made and used with due flexibility, having regard to the circumstances of each case. In the course of listening to the sophisticated arguments addressed to us, I gained the impression at times that the Section 41 calculation in particular is in danger of being elevated into a principle of law. That would be a mistaken approach. Now, the important reasoning of the judge in relation to how licenses are to be taken into account in any given case, in our case, is exactly in line with that. And if you would please now return to the High Court judge in this case at page 474 of the bundle, at Roman 3. And I picked this up at the very last line on the page, 474. The judge says, it is clearly unhelpful and liable to lead into error to be too dogmatic as to how comparables are to be treated before considering their nature. Obviously, if one has a group of precisely comparable licenses with the remaining comparables of no probative value, it's a nonsense to pollute the helpful comparables with the unhelpful. Equally, where there's an exact parallel, that comparable is liable to have and ought to have greater weight. But this is to anticipate. What I take from this passage, as cimetidine, and particularly 174, is that the use of comparables needs to be evidence and fact-led, and to say any more at this point would be an error. In the present case, the Court of Appeal had no basis for overturning the judge's evaluative assessment that on the facts of this case, and inclusive use of a larger data set was more likely to help him get to a fair estimate, not hunting for individual licenses to serve as close parallels in their own right. There is nothing in the Court of Appeal's reasoning below to support the notion that what the judge did was wholly unreasonable and no reasonable judge could have done it. In our written case, we pointed out that Optis's own expert had expressed similar views. We do not accept the criticism in Optis's written case that we are misinterpreting what he said in any way. I will give you, in the interest of time, just one reference. Please turn to page 1567. This is that expert, gentleman, Mr. Bizant, his first report. On page 1567, you look at the top of the page, paragraph 3.24. He says this, with which we agree. Ultimately, for unobservable reasons, any given license or a small set of licenses from a single licensor or licensee may be inappropriately high or inappropriately low. In my view, it's better to rely on a larger number of comparable agreements than a narrower set of comparables. The larger the set of comparables available, the easier it is to account for these factors, for example, in terms of the potential effect of hold up and hold out, associated with any given comparable or set of comparables from a given licensor or licensee. So in conclusion, we respectfully say that the Court of Appeal's finding in the first sentence of their judgment in paragraph 115 that there is the right approach is in error. A subsidiary but related question is what the Court of Appeal goes on to find in the second sentence of 115. There was no justification for setting aside the common ground of the experts to adopt some kind of unpacking to evaluate licenses in per unit terms. That is addressed in our written case, page 65, paragraph 30. And if I pick that up, 5 lines down in that paragraph, submitted the Court of Appeal was wrong to have treated the judge's rejection of the accountancy evidence as a factor that in itself vitiated his entire averaging approach and methodology, which didn't require accountancy expertise. The judge rightly perceived the accountancy experts weren't in a position to assist the court with what were essentially factual questions about the patent license agreements they were tasked with unpacking. For example, the extent to which the lump sum consideration for a license should be attributed to payment for the release of past liabilities rather than the licensing of future sales. Now, may I say we accept that insofar as the judge was critical of the experts professionally, which, by the way, he stated he didn't mean to be, let's give you the reference, paragraph 316, that was not appropriate. The relevant point was that in unpacking the Apple licenses, the experts were to a significant extent drawing on factual information provided by other people about matters that were objectively unknowable. There's no moral aspect to that. It's that the exercise they were carrying out was to a large degree computational, not applying specific expertise. The judge was, in effect, to say, to repeat what I said at the outset, he was concerned to avoid spurious precision, and so he preferred to approach the determination in a broad brush manner. Again, this was reasonable. It was a matter for him. Optis will develop its points on ground 1A in their counsel's response. There is just one standout point that it's sensible for me to touch on straight away before I come to a conclusion. If you open their written case at page 136 of the bundle and look at paragraph 122, picking it up really from 4 lines down, the gist of what they're saying is that we aren't confronting the Court of Appeal's point that not all the Apple licenses can be FRAND if you have such a wide spread. If by that they mean that not all these Apple licenses can individually serve as a close parallel, then we agree. Indeed, the judge's evaluation was that none of them can individually. And that is why his inclusive averaging approach for getting to a determination of value of the at-best average portfolio of Optis was appropriate on the facts of this case. And then on the following page, paragraph 125, Optis argues about 5 lines down this. However, they say, it cannot be right for a judge not to do their best to resolve the dispute between the parties as to which, that means which of the licenses, are the more useful. Leaving aside the elephant in the room, that is not what the Court of Appeal did either, which we'll come on to next, and the point that neither Apple nor Optis took the view that choosing a small subset to serve as close comparables was the or the only way to do it, the answer is that this trial judge surveyed the evidence and he concluded reasonably that approaching things in that more exclusionary way was not practical. Now, before I move on to ground...
He didn't entirely take that approach. I don't think he did exclude 1 or 2 licenses, didn't he?
My Lord, you're right. What he did, in line with the approach he outlined in paragraphs 290 and 291, was he said, I will err towards a larger data set, and I will exclude those which I can see serve to distort rather than elucidate. And based on that approach, he threw out at least one of the licenses. It was for a licensor called Grand Mise, I can say it, for one of the licensors, where the technology at issue was simply not the same technology. So I throw that one out, it won't help. So to that extent, you are absolutely right, my Lord. He did exclude things that he thought were unhelpful. And as he went forward, he shaved off outliers. That was his approach. But the thrust of it was not to hunt in the first place for individuals. Now, my Lord Kitchen raised with me this point about what we are saying, the judge, and the error that we have identified, and how that fits in at the outset of my address. Mm-hmm. If I may, without getting too far sidetracked, I will tell you now what our position is on that, because it may also help to complete your understanding of the judge's general approach. We accept that there was one implementation error in the judge's methodology. We flagged this in our written case on page 57, which is footnote 2. This error was to include in the group of licenses that he took, which were Apple licenses, a license from Optis to Google alongside it, which he then included in his averaging to get an average figure. The reason why we say this is an error can be simply stated, but also the solution. The judge's intention, which he explains, was that he would use a group of licenses to show the price to Apple of an annual license to the whole stack. And he says this right at the outset of outlining his methodology in this judgment. So in the judgment, if you please go to page 597, it's the back end of the judgment where his methodology gets underway. There is a heading at the top of 597 to process of valuing the stack. That's what he's doing. On the following page, 598, at the top, at Roman 8, paragraph 482, he says that within what he's setting out below, finally G, that's a column, provides a figure for the price to Apple of an annual license, ignoring past release to the entire stack. He's focusing on a price to Apple. But then in this table below, he sets out all the Apple licenses and gives a thumbnail sketch of their headline terms. But there is an error, we say, because if you go to page 602, within that, at the very top of the page, it says Google 2020. And that is not an Apple license. That was the Optis license to Google. And we say that in accordance with his own thinking, this should not have been included. And if you go back now to see more clearly his reasoning on this, to page 586, and look at the top of the page, you see paragraph 464. I can read that. Assessing the lump sum price for the stack, i.e. the total price payable for use of the standard, irrespective of selling price and volume sold by Apple, is mainly achieved through the use of the Apple comparables. The Optis comparables can't be used because unpacking introduces too many subjectivities, and in any event, for the reasons given, a lump sum must be calculated by reference to the implementer seeking to license the portfolio in question, which the Optis comparables don't by definition do. So he says, I want to focus on licenses to essentially this implement. If you now follow the footnote, 598 first, although the ad valorem price can plausibly be charged unchanged to all implementers, a lump sum rate must obviously vary according as to implementer. Although the lump sum may not explicitly be calculated by reference to selling price and volume sold, those factors will obviously have a bearing on the value of the license to the portfolio to the implementer. Calculation, and then this, calculation of the lump sum must, underlined, therefore be specific to Apple, and the Apple comparables are therefore of the most significance in this part of the exercise. So why did he include the Optis Google one? If you look in the next footnote, he says, the Optis comparables, even if unpacked, would represent the lump sum price paid by Optis's counterparties, who are all, with the exception of Google, far smaller than Apple, and so would pay a lower lump sum rate in any rational market. The error there is that although we think of Google as a large entity similar in size to Apple, we're concerned here with its handset sales business. And what the judge is forgetting is that Google's handset sales are a fraction of the size of Apple's. And so the point he misses by simply saying, well, Apple is like Google, is that with what he's looking at, it's not the same, and he can't put this in. His intention, therefore, was to use the stock of the Apple licenses as his guide, because he can assume that the level of the sales of the devices is broadly stable, it's all Apple. If I give you one final reference, if you go to page 682 of the bundle, he confirms this in the consequentials judgment. On page 682, paragraph 101, Roman 2, he was considering their proposed grounds of appeal against his judgment by Optis, and he says that there was a failure to take account of sales volume alleged when assessing the value of the stack and Optis' share in it. He says, third line, these grounds fundamentally misunderstand the court's methodology, which was to calculate a lump sum rate that was FRAND in relation to Apple. Inevitably, all the Apple comparables, he says, which apart from Google were the comparables used by the court, would have taken into account Apple's sales volumes and selling prices. These values would have been baked in and did not require separate consideration. So that is, as you see, where the judge took a wrong turn given what he was trying to achieve. He shouldn't have included the Google license in what he then went on to do. He thought that by adopting this overall approach and simply saying these are all broadly licenses to Apple, where the volumes are baked in, then I do not need to engage in the spurious precision of trying to work out what the parties assume will be the expected level of sales for each license individually. Because, as I've shown you, he thought it was essentially an unknowable subjectivity. So on this footing, if I may return to Lord Kitchen's question at the outset, and maybe park the rest of the debate for later, Optis Google was a cuckoo in the nest, and its inclusion was a straightforward oversight by the judge. The volumes of the handset sales by Google were a small fraction of the volume of sales made by Apple, and a license for Google to the whole stack would by necessity be a far smaller sum. It's not equivalent to the other licenses. So that is why we say that the solution is simply you take that one out and you recalculate. I move to ground 1C. I'm going to cover 1C, D, and 2 and 3, if I can, before we conclude. 1C is the Court of Appeal's decision to use an explicitly non-FRAND license, one it characterises itself as having far too high a rate, as the reason to propel the court-determined rate for a licence to Optis up to a level substantially higher than all Apple's existing licenses with a group of major international licensors. So at this point, I'm moving from the Court of Appeal's attack on the judge and their conclusion that there was holdout affecting all the Apple licenses, as you've seen. I'm now moving with these two grounds to look at what the Court of Appeal itself did as its own direct evaluation in substitution for the trial judge. The relevant part of the judgment in the Court of Appeal is between paragraphs 132 and 142, which begin on page 309 of the bundle. If the Court would please turn that up. Here, there are various figures, numbers, which are confidential, which I must not read out. In paragraph 132, the Court of Appeal says that all Apple licenses with the highest rates paid to major licensors are those to Ericsson, Interdigital, Nokia, and a company called Cisvel. When those rates, looked at in dollars per unit, are scaled down to reflect Optis's small share of the whole stack, the rounded numbers are those which are described in the second sentence of 132 at the bottom of the page. I won't read out. Those are the cents. The Court of Appeal then contrasts those numbers, and you see what the highest one is, with the much higher corresponding number shown at the bottom of the paragraph.
I'm sorry, what page are you on?
I'm sorry, this
That's
is 309.
Where did you start? Because I saw what you were referring to in 132, but where did you start? Couldn't find that.
I'm sorry, so I am starting in 132.
Yeah.
Oh, okay.
And in 132, the non-confidential part says that the judge says that the highest four implied Optis rates to some of the big beasts on the other side are these ones, Ericsson, Interdigital, Nokia, and Cisvel.
Yeah.
And then in the next sentence, he gives you the corresponding rates, which on the Court of Appeal's view are too low because they were artificially depressed. Do you see that? There's a range. Then he goes on, and in the penultimate line at the very bottom of that page, he compares that with the corresponding figure which you get for the Optis Google license. And I'll ask you to look at the degree of that comparison. Then the Court of Appeal draws conclusions from that comparison, the size of that difference, starting at paragraph 137 on the next page, 310, under the heading, Draw Conclusions. In paragraph 137, Lord Justice Burst says that the past Apple licenses taken alone show that Optis should at least get a rate as high as the highest rate paid to the major international licensors. His conclusion there. There's no reason given as to why that should be so, taking account of, as I say, the at best average quality of the Optis portfolio, the fact that these other licensors were often licensing other valuable property, and the possibility of hold-up behaviour by some of them, and so on.
So is this normal? Are these figures normalised?
Yes.
Otherwise, it's completely nonsensical. Because you're dealing with different sized portfolios and a different proportion of the stack.
Yes, they are.
Right.
Well, I'm sorry, I went too fast, but these are basically taken down and scaled to Optis's size. So each of them are what Optis would be paying if you take the accountant's workings and apply them through to the Optis license. So they are equivalent. And so Lord Justice Burst is right to do what he's doing,
yes,
which is to look at them in this way.
Yeah.
What happened, sorry, just complicating things further, but what happened to the other Optis licenses? Why do they get thrown out the window and just this one picked on?
They were thrown out because those were, it was really the reason I sought to give at the outset, that those were regarded by the judge as unusable. They were made with tiny counterparties where remarkably high rates were inserted in them.
Sorry, I've forgotten that. Yeah.
Yes. So the only one that is left is this Google one.
Right.
And what I've tried to show you before coming to this is why the judge, in his approach, used it at all.
Yeah.
Why we say it's an error. Here, to follow my Lord Kitchen's question, there is a direct read across. It is normalised.
Yes.
And the one number at the bottom is far higher than the others.
Yes.
And really what we're now concerned about is what Lord Justice Burst draws from this.
Yes.
So in paragraph 138, towards the bottom of that page, the judge draws another conclusion. He's now taking the Google license into account. And the key statement is in the second sentence. The simple conclusion is the Google license as a comparable shows that deriving a rate from Apple licenses on their own, either as a whole or just focusing on the four I've identified, the top ones, would produce a rate which was too low. In other words, the Google license is said to demonstrate that even the very highest rates paid by Apple to major international licensors are all too low. But why? The only rational basis would be if the Google license was considered to be, by some lights, a useful guide, a useful yardstick to FRAND. However, in the very next paragraph, the Court of Appeal gives reasons why it concludes the Google license is, in its own words, far too high. And as you're going to see, it offers no basis anywhere for thinking that even if the Google license is far too high, you can sensibly gauge by how much it is too high to let you get to a sensible estimate of a FRAND rate. And if I may begin at paragraph 139 at the bottom of page 310, the Court of Appeal here reverses or flips its own logic for having concluded that the rates in all the Apple licenses are too low. If you recall, it's done that by saying, I see the Google license, that tells me all of these are too low. And now, 139, it says the opposite. Putting the rates from the four highest Apple licenses beside Google strongly suggests that simply using the Google rate unmodified would be too high. Then it proceeds to give a second reason to confirm its finding that the Google rate is too high and indeed far too high. And it does that if we turn the page using what it called a top-down cross-check. And it runs along the following lines. top of the page, paragraph 140, it says the trial judge decided that if phone makers had to pay 15% of the selling price of their phones to cover the cost of a license to 4G, that would be too high, too much. It's the second sentence of paragraph 140. So that's his premise, and he says, I'm getting that from the judge. In paragraph 141, below that, the Court of Appeal works out that for a Google phone, Google-branded phone, selling at, it says, $470, this too high licensing fee, 15%, means total licensing payments of $70.50. That's 15% of 470. And for Optis, with its little share of the stack, not disputed in this appeal, that would mean that it is paid 27 cents per unit for every Google phone. Still, therefore, too high, 27 cents, but as you will see, or as you do see, it's a huge amount less than the license rate which you just get from the Optis Google license, which remembers the very high number on the previous page. Yes, at the bottom of paragraph 132. Then, in the last sentence of paragraph 141...
So basically, they've concluded that the rate that first arrived is useless. The
yes.
figure at the bottom of the page is useless.
Yes. Having used it as a sort of guide to say, I can draw this conclusion from it and that conclusion, as they now go on, they say, well, it's actually useless, but I'm now going to substitute another number, which actually is still useless because it's still too high, because it comes from 15% of the selling price of every phone being paid for a license, and that's the 27 cents. And if you go to the last sentence of 141, the Court of Appeal notes what the license rate implies from Optis Google would mean the total amount of cellular patent licensing fees which a phone maker would have to pay out of the $470 selling price of the phone. I'll read that number out. I can't read the number out.
So where are you looking at?
I'm in paragraph 141.
Yes.
Sentence starting conversely.
Yes. Yes, that one tells you. The sentence starting conversely tells you that if you were going by the Google rate, what phone makers, or here Google in particular, would have to pay out of a selling price of $470 for the phone is that confidential number that Lady Simler points to right at the end, the second from last line in paragraph 141. And you see that Lord Justice Burse comments that this is obviously too much for a device which has got a $470 selling price. So he says, so I can see, all of this tells me, he says, that this is just not a useful number for me as a FRAND guide. And finally, in the opening sentence of the next paragraph, 142, he says, this is clear evidence that the Google rate is far too high, and even dropping the rate to 27 cents would still be much too high. So to summarise, the Court of Appeal has given a number of reasons for concluding that the Optis Google licence is entirely out of line with a fair and reasonable rate. And we say that this use that you've now seen being made of a candidly non-FRAND Google licence, non-FRAND licence, it's the Google one, marks a departure from the Court of Appeal's own statement of what cimetidine teaches, which is to look for the true comparable, the close parallel, the best comparable.
Can I ask you, if we go back for a moment to 138, he says in the second sentence that the Google license as a comparable shows that deriving a rate from Apple licenses on their own would produce a rate which was too low.
Yes.
In 139, he concludes that the FRAND answer has to be between the Google rate and the Apple rate.
Yes.
Now, he then goes on to explode the Google rate, as you've shown us. So where does that leave the reasoning in 138 and 139?
I'm sorry, that is part of my point.
But somewhere earlier or later, he has said that the Apple rates are, by implication, not FRAND, because he, whatever the judge did, finds that Apple were guilty of non-FRAND holdout.
Yes.
So that therefore their rates couldn't be FRAND. They were bound to be below FRAND. Isn't it? That's his explanation, isn't it? But I can't remember where in the judgment it appears.
Well,
But here his reasoning is simply based on the Google license.
Yeah.
And your point is that he's using a license which he says is on any view too high, far too high, and the fact that it's much higher is a reason to reject the Apple license rates, when it's equally consistent with the Google conclusion that those rates could be reasonable.
that's right. Yes, and therefore, just to conclude my Lord Reed's point, in 138, his second conclusion there is that when I use Google, take it into account, which means use it as a form of yardstick, the conclusion is the Google license as a comparable shows that deriving a rate from the Apple licenses on their own in any way would produce a rate which is too low. As I say in 139, he reverses the logic. He says there that the Apple licenses tell you that the Google is one of the reasons why it's too high. And then over the page, we have these other reasons why the Google license is essentially far too high in the Court of Appeal's words.
Sorry, can I go back to 137, the second sentence of 137? He's saying
Yes.
the 4 Apple licenses shows that the DP rate for Optis, lower than the rates implied by Ericsson InterDigital Nokia Civ would be too low. Is that an independent reason for concluding that the Apple licenses are too low, based on what he's analysed in paragraph 132? So it isn't simply holdout by Apple that's driving the conclusion of the court. It's the comparison with these other licenses.
No,
Am I right?
I'm sorry, I took this too fast. So 138 is where he begins to bring in the Google license.
Yes. No, I understand that. I understand.
Prior to that, and you're right, my lord.
Second sentence of 137.
What he's doing is he's saying, I'm looking at these Apple licenses, and you see the rates on the page before.
Yeah.
And he says, putting them together shows that a rate for Optis, on a comparable basis, lower than that, would be too low.
Yes.
That is the consequence of the earlier reasoning that I was examining this morning.
Right.
And his view that the Apple licenses are all infected by the holdout.
Yes. Okay.
That's how he's getting there.
Okay.
What I'm doing now is really just trying to walk you through the Court of Appeal's
I understand.
use of what we have here as a non-FRAND license. They say that they are drawing on cimetidine, essentially. If we please go back in this judgment to page 290, paragraph 35.
Sorry, paragraph?
I'm sorry, page 290, bottom of the page,
Right.
paragraph 35. And there's a quote from cimetidine. So just so you can see what cimetidine was in the Lord Justice Lloyd was envisaging, which is quoted by the Court of Appeal. The object of the comparability exercise, in this as in any other branch of the law, is to find the closest possible parallel. If there is an exact parallel, there's no point in looking any further, and so forth. And what he says is if you find your one that's close enough, you can stop there. That is not what is happening here with the use of this Google license.
I have to say, I've never come across a valuer in other areas of valuation who would have said that. They always want to look at a range in order to, as a check on any that you look at. You know, the house valuations, for example, to give the example that Lord Legate used this morning.
Yes.
You know, you could have a house next door, but it was sold a week earlier, but you wouldn't look at that and ignore all other evidence because it might have been a rather random sale.
My Lord, you're right, and that's in line with what I showed you a passage from their expert and how he approached the benefits of having a larger data set. The further point in this case is that the judge, in his estimation, said that I can't find each of these licenses taken by themselves a close parallel, which was another explanation for looking at collectively. Before leaving...
And your point is that the Court of Appeal themselves have effectively accepted that the Google licence wasn't a close comparable.
That's right. That's right. They refer to it later on as a best comparable, but it is not by these lights. So if you then look also at paragraph 36, I'm sorry to complete this on page 291, in the Court of Appeal judgment, they add certain further propositions about cimetidine and what it tells us. And I draw your attention to the warning note, which is sounded in the second half of the first extract, which is from paragraph 173 of the first instance judgment in Unwild Planet.
Sorry, which paragraph
This is
are you in?
paragraph 36, 291, page 291, Court of Appeal. Lord Justice Burst says, I'm going to add two short extracts. That's to add to what he's directly set out from cimetidine, from his own judgment at first instance in Unwired Planet, where he's talking there, in that first instance judgment of his, about cimetidine. And he says, just reading, it's paragraph 173 of his earlier judgment within paragraph 36. Yeah. He says, that's also not what Lord Justice Lloyd in cimetidine said one mustn't do. Instead, he said that assuming there's no exact parallel, once true comparables have been determined, one should be careful not to dilute them by reference to other cases which are not truly comparable at all. And then he goes on to say that you shouldn't. I'm sorry. That's the quote. This is a case where you do not have in Google a close or exact parallel. As I say, by the Court of Appeal's own lights, this ought not to be considered a close parallel, a true comparable, or a best comparable. And what has happened is that the Court of Appeal has attributed weight in a nebulous manner to a past license which it itself knew, beyond doubt, was non-FRAND. In our respectful submission, this approach runs counter to the fundamental objectives of the ETSI organisation. It introduces arbitrariness into valuations and uncertainty where there should be none, or it should be minimised. It leaves the community of licensees, by which I include the wider community, including under other organisations, unable to predict how to find FRAND rates or to plan their businesses properly. And it doesn't take care to strike a balance between, on the one hand, the interests of the downstream market and consumers in affordable prices and competition, and on the other hand, the importance of giving a fair remuneration to SEP owners to reflect the true underlying value of their patents. Now,
well, it would be marvellous if there was a method that was appropriate for all cases and produced predictability, but part of what you've shown us is that there isn't.
That is so. Optis makes only a few weak points about this ground in its written case. It's pages 138 to 139 of the bundle, paras 130 to 133. The only one that I'll pick up now is the contention in paragraphs 131 and 132 that a past license doesn't need to be a close parallel to be a true comparable or the best comparable. And the suggestion seems to be that if you've got nothing else apart from this past license, it becomes, as the last man standing by default, the best comparable. Ergo, it is available to be used in the way the Court of Appeal has done, namely to discredit all the Apple licenses as too low and to mark an initial upper bound for a new range of rates which it creates itself. This, in our submission, is not compatible with any fair reading of what the Court of Appeal cited as the key proposition in cimetidine, back in paragraph 35 of its judgment, and at no point does Optis grapple with the essential difficulty. The Court of Appeal itself has found that the Google license produces effectively outrageous rates. That was precisely the same conclusion that the trial judge reached below when he considered the unpacked rates from this license as indefensibly high. In short, nothing can be deduced from this license about fairness and reasonableness of other rates. The Court of Appeal's use of this license to do that was unprincipled and we say wrong. That is ground 1C.
Both were wrong to take it into account. Both the judge and the Court of Appeal were wrong to take
that is right.
A particular license into account.
Yes, and for different ways. The one for throwing it in with his others in the washing machine of the averaging, the other for treating it in this way.
Yeah.
So now the final ground under ground 1 is 1D. This is the complaint that the Court of Appeal's method for determining a FRAND license rate, in substitution for the judge, the wider method was wrong in principle. The relevant paragraphs in the Court of Appeal judgment here are 143 to 146, page 311 of the bundle. These 4 compressed paragraphs contain the entire gist of the reasoning. The Court of Appeal's starting point is the question you see in the first sentence of paragraph 143. The question, therefore, is where to go down from 27 cents EPU, dollars per unit.
Well, he's used each of the Apple licenses and the Google one to discredit each other, so he concludes they're both wrong, and then he thinks the best he can do is to pick a figure in the middle somewhere between the 2 wrong valuations.
Well, he's used them as a Mexican firing squad to discredit each other.
Yes.
But then, having done that, he now takes a range, as I'll show him. He's at the bottom of it is the Apple license.
I know, and then he chooses a figure somewhere in between.
And then, well, he then takes as the upper bound of this new range something which isn't Google, but which he still says is much too high, is 27 cents. And he says at 143, the question therefore is where to go down from 27 cents. So this is now the upper bound of their range. And just like the higher figure from Google, it is consciously non-FRAND. It is consciously still too high. An immediate problem arises with the 27 cents, even if you leave to one side that it's consciously non-FRAND. The reason the Court of Appeal has this figure at all is because of the cross-check you remember it had been doing just above, relating to Optis Google. But now, in paragraph 143, Optis Google is in the rearview mirror. It's been left behind. And what it's now doing is setting an upper bound for a range based on the proposition that if a given licensee, whoever they are, has to pay 15% of the selling price of their phones in licensing fees for 4G cellular connectivity, that's too high. And the origin of that is the second sentence of paragraph 140. If the Court of Appeal is working on that new basis, why should it now use the selling price of a Google phone, $470, as its royalty base? Why wouldn't you take, as your unreasonable upper bound, 15% of the price of a still feature-rich smartphone selling at $125? Or, and I say Lord Justice Burse was uncited as to this because he wasn't the trial judge, the selling price of $250, which Optis's accountant said after reviewing the industry was the appropriate capped price if you are unpacking Apple licenses. That was his way of guarding against SEP license fees taking an undeserved slice of the value of an Apple iPhone, which has nothing to do with these patents. And to see this, if you please turn up page 1582 of the bundle. This is Optis's accountant's report, the third report. And at the bottom of page 1582, paragraph 410, the accountant says it's appropriate to apply a cap when you're unpacking Apple licenses into per unit rates. He explains the reasons, which include a point made by Optis's licensing expert that phones above a certain price bracket don't get much more benefit from cellular technology than lower priced phones. And on page 1583, the facing page, he looks at some evidence to help him decide what the right price threshold should be if you're licensing. On page 1584, in paragraph 415, foot of the page, you see from the non-confidential sentence under the blue that the right amount, in his view, is $250. But if you return to the Court of Appeal's judgment, they have stuck with $470 to get to their upper bound, their new upper bound of 27 cents. They could, or we say should, if they were going to do something like this, have got a number around half of that figure, because instead of $470, if they'd said it was $250 as the right price, instead of 27 cents, you get something like 13.5. But the Court of Appeal didn't have before them the full evidential material from the trial to think about this or to apply even their own methodology soundly. And that is why they stick with the 27 cents. And their next step is to try, as my Lord Legate says, to find a point in the range between the number that's too high and the number that's too low, derived from the highest amounts paid by Apple to international licensors. And the approach they take is described in 143. The Court of Appeal says there are two considerations to take into account. First is a principle that if there could be a range of FRAND rates, the principle or the consideration is that the patentee is entitled to the top of the range. The second is the nature of the evidence it had, and I quote, does not justify fine distinctions. We say quite, and this is a matter to which I return under ground 3. But may I focus on the first of those considerations, the principle that there could be a range of FRAND rates, the patentee, the licensor, is entitled to the top. In our grounds, we speculated, I'm afraid, that this might be derived from the Court of Appeal's judgment in Unwild Planet 2018, in which Lord Kitchen was a member of the court. And now Optis, in its written case, appears to suggest this is the case. It's paragraph 136 of its written case. And they say it supports the Court of Appeal here. In our submission, the point in Unwild Planet Court of Appeal is a quite different one, and it doesn't support this proposition. You please open up Unwild Planet Court of Appeal. It's at page 3344, and in it, please go to the relevant part of the judgment, which is on page 3384. 10 paragraphs between 124 and 125. It's quite straightforward, I hope. The issue was whether more than one set of contractual terms could be determined by a court to be fair, FRAND, and if so, how the court should deal with that under the EWCA framework. Please read paragraph 125. The court says, in our judgment, this is more of a theoretical problem than a real one. If the SEP owner and prospective licensee can't agree on the terms and royalty rates of a FRAND license, and the question of what's FRAND falls to be decided by a tribunal, whether a court or an arbitrator, then the tribunal will normally declare one set of terms as FRAND, and that will be the set of terms the SEP owner must offer to the licensee. If, however, the outcome of the proceedings is that two different sets of terms are each found to be FRAND, then in our judgment, the SEP owner will satisfy its obligation to EWCA if it offers either one of them It will in that way be offering an irrevocable licence of its SEPs on FRAND terms. So the issue there was whether more than one set of contractual terms could be determined by the court to be FRAND, and if so, how you deal with it. And the point is confined to the observation that if the outcome of proceedings is that you find two different sets of terms are FRAND, a SEP owner satisfies its obligations by offering either of them to the respective licensee. But here, by contrast, the situation is that there's an uncertain range before the court, bounded by a non-FRAND point at the top and a non-FRAND point at the bottom, and the court is undertaking the task on this method of choosing a single point to say it's FRAND. The more theoretical than real problem identified by the Court of Appeal in Unwired Planet is not the point here. Moreover, when the court is choosing a single point, say it's FRAND, one must recall it is pursuing the EWCA objectives. And those objectives do include lowering product costs, fostering competition and innovation between manufacturers to the benefit of the public. The aim is not promoted by giving the SEP owner the benefit of the doubt when confronted by what is pure uncertainty. It must be addressed by determining a single point which promotes the fundamental EWCA objectives and which strikes a balance between that and the additional objective to ensure the patentee gets fair value for its invention. And this
isn't really saying anyway, is it, that there's a range of fair values? It's saying that there's uncertainty about what the appropriate value is, and there's a range of possibilities. And if you're faced with that situation, surely you choose the middle point in the range, not an extreme on the range.
Yes, that's it. I'm sorry, it's a better way of putting it. Essentially, a range here, as in an uncertain range.
You're not certain where in this range the true value falls. Well, then you pick the middle value, because then at least you've got the, you're more likely to be wrong either direction. So if you pick one end, then you're skewing it one way.
Yes, and particularly if you say that one errs in favour of the patentee.
Yes, or either way, it would be equally unjustifiable.
Yes, we agree.
I think it is fair to say that this particular point was not before the court in the Court of Appeal in Unwired Planet. I mean, the judgment says what it does, but the particular point that you're now putting to us was not, as far as I recall, it before the Court of Appeal in the Unwired Planet case.
My Lord, if it's an observation which has grown in autopsy, then that would, without it being essentially grounded in what that court had to decide, then I fully agree it adds to the concern about the way that it is being used here. And although I won't go into it, this point derived from that case is also being picked up in other cases.
On valuation, in terms
yes.
of a range?
Yes, so Mr. Justice Deed's recent judgment, and I shan't detour into it, he has a section on this principle.
Right.
Well, I can see that if what's being talked about here is if an offer is made of a particular rate, and what the court has to do is to determine whether that's a fair and reasonable rate, it might decide that it is, and it might be compatible with that, but there might also have been another rate that would have satisfied that test. The court doesn't have to decide that. But where you're asking the court to decide what the rate should be, then surely it has to do the best it can, and not err in favour of one party or the other.
Yes, and therefore we say that to the extent that this consideration, which the judge says he's taking into account in finding a point, was applied, it is not a correct approach.
It may or may not be helpful, but I can dimly recall a similar debate about negligent valuation when there was an issue whether you went for some notionally true valuation of the property or the highest non-negligent valuation on the way to deciding whether the valuer had been negligent. I got a feeling that the court didn't go down that latter route in the end, but there was quite a lot of contention that it should. beyond that, I can't be precise, but it just struck me as an analogous kind of argument. In a situation where what we're really concerned with here is whether the SEP owner is charging something more than what is FRAND as a condition of a license and threatening an injunction unless he gets it.
Yes. Yes. My Lord, we agree. There are actually a number of other contexts, and in the competition sphere, there's a judgment by Lady Rose when she was chairing a tribunal, a case called Albion Water, about whether one should assume that a fair rate is the highest rate that could lawfully have been charged, or you look for a reasonable rate, as it were, sort of midpoint.
We had this last year. I was just reminding Lord Leggett in the case about LIBOR and Euribor, a criminal appeal, where the duty of the bankers was to give a best estimate of the rate at which funds could be borrowed on the relevant market. And the Court of Appeal had thought they had to give, if it was a range, they had to give the lowest figure, and we said no, that was wrong. You then have a systemic bias towards erring low. And we said rather you should be choosing a midpoint.
Yes.
That's the case of Hayes and Palumbo last year.
I agree respectfully with all that's been said. If I may, I won't detour in particular into the Mr. Justice Mead judgment, but there is an interesting development at this point there. And it leads me to the Court of Appeal's second consideration, paragraph 143 of the judgment, and how the court deals with that. The Court of Appeal has created for itself a large range between two non-FRAND points, and then it takes three evenly spaced points of its own device within the range: 10 cents, 15 cents, and 20 cents. 25 cents, I'm sorry. And it declares in the penultimate sentence that these are the realistic options. They were not, and this was a matter of subjective choice, with very profound implications for this court-determined license in its own right for Apple, and as a precedent looked at, as I have said at the outset, by the entire industry, trying to see how licensing is done in this sphere. The Court of Appeal then chooses between these 3 points, essentially based on, we say, no adequate reasoning at all. It dismisses the lowest of the numbers, 10 cents, for the reason at the end of paragraph 143, by saying it is too far from the Google license.
This is after they have rejected the Google license.
Yes, it is.
As a realistic figure.
Yes, exactly. So here again, and it is problematic for the confidential reason too in the last 6 words, which I can't read out. You can see for yourselves.
Yes.
I'm sorry, it's the last 6 words.
Yes.
Essentially, this is an assertion because it had no basis for gauging that point either, what is too near or too far. Then, in the next 2 paragraphs, 144 and 145, it asks itself what the 2 remaining dollar per unit rates would imply for the total price that manufacturers have to pay in licensing fees. The end of 144, paragraph 144, you see it says that the rate of 20 cents would mean a total stack price, the total amount you pay for licensing, $50. And then it asserts, without any underpinning reasonings, that this is too high a price, both for an Apple phone at the time and for a lower-priced Google phone. It doesn't consider what it would mean for a phone at any other price level. And finally, in paragraph 145, the Court of Appeal plumps for the final number, 15 cents, saying it's using Google on the one hand as a best comparable, even though, as my Lord Reid points out, it's been left behind at this stage, and the highest Apple licenses on the other hand as at best comparables, even though all of those are supposed to be too low. It notes what this rate entails for a payment for the whole stack, namely about $40, and then without any comment and with no underpinning reasoning, it says what proportion $40 represents of the selling price of a Google phone and an Apple phone. Standing back, our submission is under ground 1D, this ground, is that this manner of determination is an error for the reasons we give in our written case, paragraph 68. And in a nutshell, it's inspired by non-FRAND rates, it is subjective and unreasoned, and therefore antithetical to the needs of industry for consistency and predictability. Third, it appeals in an unclear manner to a principle that if there could be arranged, the patentee is entitled to the top. And fourth, it overrides the trial judge's findings of fact concerning the Apple licenses. There is nothing in Optis's response to this ground in its written case that I will pick up at this juncture.
In terms of subjectivity, and leaving aside your point for a moment about anywhere in the range, I mean, the judge himself, by all accounts, looking at his judgment, engaged in quite a lot of subjective assessment about where the appropriate figure should lie and what he should take into account. And at one point, I think he used the expression, it would make an accountant blush or something.
On one point he did.
Yes.
And so one has to be a little bit careful, does one not, about subjectivity, because this is inevitably a subjective, to some extent, a subjective assessment, taking into account either the evidence you've heard if you're the judge or if you're the Court of Appeal, the argument you've heard and the evidence you've been shown.
My Lord, yes, and there's the rub. In your concluding words, you say, because the judge has, to use that phrase again, the sea of evidence. Yes, the judge has to make an assessment, an evaluation, and at certain points saying, I do not have precise material, the judge says, I must make my assessment based on the sea of evidence. The Court of Appeal is not in that position.
And so your submission is it should, at this point, if they had correctly concluded the judge had fallen into error, they should have remitted it.
So this is our ground three. That's this is our ground three. Yes, the point is, rather than, as my friend says in their written case, the judge's judgment has to be completely dismissed, and you have to pick out what you can to reach a result as the Court of Appeal. If you really have no straw with which to make bricks, if that really is your situation, then you remit for the job to be done properly. If it were the case that they were right, that you have to try to find the closest individual comparable, you send it back for that to be done. But you do not, at the Court of Appeal level, seek to undertake a multifactorial assessment of this kind without the straw to make the bricks. That's our case.
I think your submission may get some support. It occurs to me that Lord Shaw of Dunfermline's famous remark about the use of a sound imagination and a broad axe was in a case of patent infringement, where the point of the observations was the difficulty of trying to arrive at a precise calculation in some types of claim, of which patent infringement was one. And I think in almost the next sentence, he says something to the effect that in that category of case, the greatest weight should be attached to the assessment of the trial judge.
Yes.
I mean, obviously, if the trial judge gets it completely wrong, then that's another matter. But you start off allowing the trial judge a good deal of slack because of the sheer difficulty of the task he's faced with.
My Lord, yes, and this I am now coming to under ground three, which I will attempt to...
Is that Watson-Laidlaw?
Yes, that's it.
Watson and Laidlaw, yes. Exactly that point. The trial judge is the one to whom the task has been given. They have the sea of evidence, which the appeal court does not. And even though a broad brush or broad axe needs to be applied, they are in the best position to do it. If you do not have it and yet you apply a broad axe anyway, you cannot reliably do so.
Yeah.
At one point in the
Well, it isn't simply that the Court of Appeal isn't in as good a position. It's also to do with the division of responsibilities between different levels of the judiciary.
Yes.
You know, it's a function of the trial judge to carry out this exercise, and the Court of Appeal is slow to intervene if the exercise is of a kind that Lord Shaw was describing.
Yes. So, my Lords,
That's been recently reaffirmed by this court in a very recent patent passing off case.
that's the one I'm about to look at.
I thought you probably were. But the point that's taken against you is that that's all understandable in the context of deciding whether you depart from the court below. But if you have decided it for reasons which stand up that you need to depart from the court below, where do you go then?
Yeah.
The question is, how far does that principle
Apply in this way.
apply across to the second decision which you had to make?
Yes. And I'm going to be dealing with that, I hope, before finishing.
Okay.
So,
I'm not sure whether that's really a different point from the points you've been making, is it? Because if the Court of Appeal had done a job which you couldn't point to any flaws in, then we might be very disinclined to say that that shouldn't stand. But your point is that here, if you're right, what the Court of Appeal substituted was itself flawed, and that so then.
yes, my Lord Legate's absolutely right, and I'm grateful. The ground I've just been covering is all to the effect that taking as the premise that the Court of Appeal can embark on this process, let us look at the way that it has done it. And I've shown you that in what it did, it approached it in a manner that is, I say, antithetical to the way this regime is meant to operate, using non-FRAND licenses as the guide to pull things up, create a range and so forth.
We don't have to decide whether the court, if that's right, whether the Court of Appeal could have used another approach that would have been all right.
That is so, yes. Yes. You can see that this particular approach they took is not safe. So I turn then to ground 2. Please turn to page 77 in the bundle, where you find ground 2 set out in our written case and the beginning of the written argument, halfway down, page 77. The essential proposition here is that to discharge its functions as a FRAND rate-setting body properly, in line with the EWCA objectives, a court needs to attend to 2 matters. Both of those matters are in the nature of cross-checks when you have a candidate FRAND rate to ensure that the final rate you determine is workable in the marketplace. The first is to consider the implications of the proposed FRAND license rate, your candidate, for the aggregate burden that the licensees will have to bear if that rate is grossed up, as well as the reasonableness of this burden from the point of view of the wider industry, and not only the individual licensee. Remembering that in Unwired Planet, this court referred to the objective of determining a single rate applicable to all. The community of manufacturers who produce products using the relevant standards do not see this as a decision limited in its implications to Apple, but as articulating a valuation for the relevant standard potentially applicable to them. And that includes various of the interveners who've lodged submissions in this court. So the first cross-check is to consider the overall picture, what it means for overall licensing fees. The second is to do what the trial judge exhorted in his judgment, which you find in paragraph 364, top of page 546 of the bundle. This is an interesting point of a slightly different stripe. He says, really write the last 4 words of the previous page. I consider it's important this judgment lift its eyes from the narrow facts and the outcome predicated by those facts and scan the wider horizon so that consistently with the facts, this judgment sits as well as it can in the range of decisions that have been articulated by other courts, including the domestic case of Unwild Planet first instance, but also the decisions of courts of other jurisdictions. And we say that in both these respects, the Court of Appeal's own rate determination was wanting. And if I may take first the point on attending to the aggregate royalty burden, from the point of view of EWCA and similar organisations, ultimately it's the total royalty burden that phone makers or whoever need to pay that actually matters, because it's that which affects their cost base and determines whether the markets they operate in are going to work well or not, and so that the standardized technology is widely diffused. And to quote the Supreme Court in Unwild Planet at the end of paragraph 4, consumers benefit through more convenient products and services, interoperability, lower product costs, and increased price competition. In this case, the rate determined by the trial judge did not depart from the envelope of existing market rates being paid by Apple to other licensors, which were the evidence in the case. The judge took that range and he worked with it. Indeed, the judge's entire approach was to arrive at an average value for Optis for an at best average portfolio. But you've now seen the Court of Appeal's approach. That meant consciously picking a rate much higher than any of the existing market rates from Apple's licenses considered usable by the court, and so it marked a new commercial high point. An implied total burden that sits within the existing rates, like the judge's, you can presume prima facie is reasonable in this dimension, but a rate-setting court that consciously wants to impose a higher implied total burden on the licensee ought, we say, to take steps to ensure that the outcome still strikes the fair balance between SEP owner and implementer interests envisaged by EWCA. If you focus only on Apple for the moment, it's obvious to anyone who knows the iPhone that it's not a bare brick phone with cellular connectivity as in the early days of mobile phones. It's a multifaceted device, has lots of features which have got nothing to do with cellular connectivity, but these innovations that go into that have to be remunerated commercially out of the same revenues from selling the phone. If those revenues are diverted to the cellular set licensors, such as Optis, this reduces what's available to remunerate the other inventions and available to allow the profit. So as a result, if a first instance rate-setting court, let alone an appellate body, proposes to impose a rate that punches through the ceiling of what a manufacturer such as Apple has paid in the past to a group of major licensors, then such a court ought, we say, to consider the commercial implications to do the job correctly. In the present case, the Court of Appeal did not do that. The closest it came was to ask itself at paragraph 145, which you find on page 311 of the judgment, what percentage of the selling price of a Google handset and of 2 Apple phones would be accounted for by the total licensing fees, summing to $40, based on its approach. The answer in the case of an Apple iPhone, depending on the vintage, was between, it said 3.9% and 6.3%. Seeing those numbers appears to have given the Court of Appeal satisfaction or reassurance, but it's unclear how. How was it to judge that those proportions, which went beyond the figure implied on any view by all of the Apple licenses in the group, was appropriate in market terms? That's for Apple. And we say the same point extends to the wider industry watching this case beyond Apple, as the intervener HMD has most eloquently explained. And perhaps if you would turn up HMD at page 183 of the bundle, we start at paragraph 12 on page 186. This intervener says in 12, first, court-determined rates, the aggregate burden derived from them and the associated valuation methodologies are often very important reference points in commercial negotiations. Therefore, the quality, consistency and predictability of such decisions are of vital importance to companies like us, who don't have the same extensive resources as the parties to this appeal to dedicate to negotiations and litigation. And they go on, I go to paragraph 15, page 187. First, this outcome doesn't reflect the rates determined by the market itself. This is the Court of Appeals, they say, including as evidenced by the publicly stated revenues generated by key set licensors in the market and is destabilising. And at the end of that paragraph, the consequence is the unfair inflation of prices across the industry, driving up consumer costs and reducing resources available for R&D. And finally, paragraphs 17 and 18, beginning on page 189. Second, the Court of Appeal adopted a flawed valuation approach that led to an implied total burden of $40 for 4G SEPs. But this doesn't reflect our experience of commercial reality. As we state above, the majority of our feature phones sell for approximately $30 or less. This in itself demonstrates why $40 can't be a reasonable aggregate royalty, because it's more than the device selling price. And at 18, if I take it from halfway down, 7 lines down, if the value of 4G technology is assumed to be the same between different cell phones, the appropriate comparison would have been against the selling price of 4G feature phones, i.e. approximately $30, and more representative basic level 4G smartphones.
This assumes, though, that you negotiate the same rate no matter what the phone it's going to be put into, and that's not straightforwardly the case, is it? I mean, one can argue about that. Yes. There's a case for saying, well, if I'm contributing my patent for something that's going to be sold at a huge price, it's reasonable to negotiate for a higher sum than I would if I was contributing it to some small valued item.
Yes.
And that's how the commercial world might work.
Might, my Lord, yes.
I'm not saying it does, but I'm just saying this seems to assume the opposite.
My Lord, you're absolutely right, and that is the key point. So let me just deal with that. There is no finding that percentage of the selling price approach, you judge it according to each phone, is the right way to approach things, articulated by the Court of Appeal. On the contrary, what you do see in their judgment, and I'll be quite brief about this, is that they refer to the figure of the $40, and then they apply that figure first to the Apple iPhones at the different prices, $1,000, $625, and they apply the same figure, the $40, to the Google handset at the $470 mark. So one might well conclude from that, as these interveners have, it does look like they are saying that this is essentially the single price.
Well, you might conclude, though, that was the ceiling, and that if it was a very cheap item, it might be lower than that, but it wouldn't be high.
One might, but what one sees is that for different priced phones in the Court of Appeal's judgment, going down to the 470 mark, at least for Google, they're just applying the same figure.
Yep.
And you'll recall also, I'm reminded by Mr. Nicholson, I think I took you to the fact that Optis's expert said that when you're considering the right price of a phone, after which you should stop charging a higher price as a percentage of the selling price, it was $250, so it's very low.
Right.
So I make no more of it than that, just to say that the way that the Court of Appeal has articulated it, this point about the need to look at the aggregate burden and the way it's been approached is a matter of concern, because certainly the Court of Appeal's analysis is consistent with what I say. So I'll turn to the second part of ground 2. This is the proposition that rate-setting courts ought to see how their determinations fit in the set of prior court decisions in the field, not just foreign judgments, but domestic judgments. That is what businesses across industries worldwide actually do, as a number of the interveners confirm. I took you at the very outset to the Motion Pictures Association. We've already seen this in HMD, paragraphs 12 to 13, where they say that this figure is of relevance to us, and it is imported by licensors into the negotiations that we carry out. This Court of Appeal judgment echoes in further negotiations. But if I may give you just a few more references. Intel, which is at the bottom of page 210 of the bundle in paragraph 30. In paragraph 30, they simply make the point that market participants look to these decisions in order to guide what they do. I've taken you to the Motion Pictures Association already. The other reference is Tunstall, which is at the foot of page 246, the bundle, the relevant part. And it's paragraphs 17 to 20. This is a little British healthcare company, and they say that they place significant reliance on court decisions when planning their own commercial activities and when negotiating their licenses. I shan't read through it in the interest of time, but in 17 and 18, they talk about the importance that in negotiations is attributed by business people in the real world to all of these court decisions.
A measure of consistency would obviously be helpful for everybody.
Yes. And so one then comes to the question of the extent to which a rate-setting court, this is a matter of approach, can look back at these earlier judgments and see, as the judge had said in the part I took you to, how does my determination fit with these earlier determinations? The two relevant paragraphs in the Court of Appeal judgment are 44 and 45 under the heading Unwild Planet High Court, UPHC and Hollington and Hewthorne.
Page
292. Apologies. Foot of page 292 of the bundle. Paragraph 44 refers to the rule in Hollington and effectively endorses it in this field. I should enter one caveat. It says neither side challenged this proposition about admissibility. That's not quite right. For our part, we did refer the Court of Appeal, for example, to the striking fact that the recent decision in the interdigital licensing case had actually found that the Apple license from interdigital, it's one of the same licenses in this case, was at too high a rate to be FRAND and not too low a rate to be FRAND. I can show you that if you go to page 26, well, I can go straight to the Court of Appeal, 2755 in the bundle. 2755. This is Lord Justice Arnold, Should be 2755.
Paragraph.
Sorry, yes. So in that, if you look at paragraph 110, he records what the judge below, Mr. Justice Mellor, had found. Due to Apple's unique status in the market, the judge doubted Apple, 2016, one of our licenses here, was a useful comparable, but considered that, quote, the rate derived from it may nonetheless be useful in indicating an upper bound. He doubted that Apple 2016 represented a depressed rate. So that's Lord Justice Arnold in the earlier case, having made that comment at the same time as reaching the conclusion in this case that all of these licenses, including that one, are at depressed rates. So there's the incongruity. Come on to comment on what use one can make of that, which is the question here in just a moment. If we go back to the Court of Appeal, in paragraph 44 on page 292, they first say in that paragraph that Hollington and Hewthorne applies in this field, and at paragraph 45, they refer to foreign courts and say that the decisions of foreign courts can be taken judicial notice of, but this is not, they say, using them as a source of admissible evidence, last sentence over the page, far from it. Far from it, but it is helpful to see what is happening. Our submission
There's an undistributed middle between those two paragraphs, which is...
I'm sorry?
There's an undistributed middle between those two paragraphs, which is whether the decisions of an earlier English court are helpful to see what is happening, even though not admissible as findings of fact.
Absolutely. We understand this to mean that Hollington and Hewthorne says you're not looking back at the earlier licenses, which are domestic, and read together with paragraph 45, there's the reference to the foreign courts.
Yes.
And there, the statement is that when you look at what they have done, that's not admissible evidence, but it's helpful to see what is... It's not a source of admissible evidence, but it's nonetheless helpful to see what is happening. So...
And what's your submission, that we should look at this earlier decision to see what's happening, or more than that?
That's it. We submit that in this field, in this type of case, where business people themselves, the interventions I've shown you, routinely themselves use these court decisions in their discussions with each other, the rate-setting court, which is intended, this court's judgment in On My Planet, to reflect commercial practice, should do the same. They should be able to do it if that is indeed part of the conversation between business people.
It's odd you'd say that you can look at foreign decisions but not decisions in this country.
Yes. So our submission here is that the trial judge was right, that you should try to situate what you're doing in the judgments that have been given in this jurisdiction as well. And it should not be limited to foreign courts.
It's a slightly special situation here. HMD tell us that, and they're not the only ones, that judgments on FRAND are relied on in the market.
Yes.
So they're treated by the market as relevant evidence. And if a court is trying to arrive at what is ultimately a figure tied into the market, it's difficult to see why the court should ignore that evidence.
That is, my lord, I agree. That's the thrust that we say.
You're relying on the conclusion that the court reached in the previous case as sort of objective fact. You're not relying on the earlier judge's opinion, and substituting that for yours, which is the Hollington and Hewthorne type of mischief.
Yeah.
Yes. Or if Hollington and Hewthorne applies as a rule here, the more important principle that should be attended to is that to the extent that parties themselves are using this in their negotiations, then courts which are seeking to replicate the commercial decisions ought to be doing.
Well, that's certainly true, but at a trial, then it would be open to parties to say, as a matter of evidence, that's what's going on.
Yes.
And then it would pass Hollington and Hewthorne with flying colours, because it would be market evidence as to the relevance of a reported case.
Yes. These past judgments, and as the interveners have said, the reasoning in them, which is scrutinised with great care, they are, in a sense, litigation facts.
And it's the long stop. I mean, it's what the parties are going to end up doing if they can't agree. They're going to be back in court in front of a judge trying to set a rate.
Yes. And when they are in front of court setting rates, the court which is setting the rates, we say, should be able itself to consider that the rate it sets
It's consistent with
is
its
consistent
previous
with the
decisions.
previous, yes. So how does Optis deal with this in its written case? At paragraph 153, near the foot of page 144, they argue, from 4 lines down, that considerations of comity extend to the prior decisions of UK courts too, given that the UK courts set global rates and have effects internationally. Now, we do not accept that comity is the right principle to bring into this discussion. However, in the result, we now do seem to be ad idem,
Yes.
although it's not the way that the Court of Appeal has approached it in paragraph 45. But Optis disputes that it's consistent with Hollington for a court such as the Court of Appeal in this case to look at what the FRAND rate it's recently determined earlier is and what it means for total licensing fees if what you're doing, they say, is mixing and matching, because there were some stack shares used in this case as part of the judgment, and one took the earlier royalty rate from the previous case, applied the stack share that's in this case, and you see from that that the rate in the aggregate that you get from the earlier case is a far smaller number than $40. The figures are illustrated in our written case at page 79. There's a little table in colour. That table's within paragraph 74. And it shows the contrast between the implied total burden in this case, that's the $40, and the implied royalty burden in the earlier case, which is around $6. It's a point that's very simple to appreciate, and it's been referred to by a number of the interveners. Optis says, well, this is mixing and matching, and it adds in its written case, which is on page 143, para 148, before receipt of Apple's case, this is page 143, para 148, before receipt of Apple's case, it was a puzzle as to precisely how $6 was calculated, causing Optis's representatives considerable difficulty. Now, we say that's maybe right, but it's a surprising submission, given that in Optis's notice of objection to our grounds, very shortly after the point was initially made, Optis's representatives stated how the $6 figure had been derived without referring to a puzzle, and that is page 893 of the bundle, paragraph 14D, where what they simply, page 893 at the top, letter D, as to the nearly 7 times lower comparison, that's not in evidence. It's based on Apple's own calculations, comparing $2 per unit aggregates, whereas the Court of Appeal analysed things using a different paradigm, they say. All we say is that at that earlier stage, the fact that this was a puzzle to them was not a point that they took. So in summary, on this other aspect of ground 2, our respectful submission is that in this field, where consistency and predictability of court determinations is vital, and where industry parties are alert to the differences between FRAND determinations in different cases, a FRAND court ought to take into account how its determination fits with those made in other cases before. and for that purpose, it may have regard to the findings in earlier decisions in the same way that the business people will do. My Lord, in the remaining time, if I may, I shall attempt to get through ground 3. Ground 3 is set out on page 82 of the bundle in our written case. Please turn that up. This is the contention that if the Court of Appeal was right that the judge erred in principle in his approach, it shouldn't have remade the determination itself then and there. It should have remitted. And I propose to deal with this ground and then address the converse situation, if convenient. If our case in this court on the valuation grounds succeeds, if you agree that the Court of Appeal was wrong to overturn the judge's approach to the valuation for the reasons it gave, how should this court now dispose of the appeal? And I start by setting out the central propositions of law on which we rely for ground 3, and then I take you to 2 authorities, one anticipated by my Lord Briggs. I'll then apply those propositions to this case. Proposition 1, the critical starting point when the appeal court's considering whether to step into the judge's shoes and take a decision itself, is to ask itself, what is the nature of the decision being made? And in particular, is it a multifactorial assessment? Proposition 2, if the decision at issue is a multifactorial assessment, then restraint is called for on the part of the Court of Appeal. Rarely, if ever, should it proceed to take its own decision based on the material placed before it on the appeal. And Proposition 3, finally, in particular, where it's apparent that necessary findings haven't been made by the judge, the Court of Appeal should remit. It will not be just for the Court of Appeal to undertake an evaluation itself. There are 2 authorities referred to in our written case to take you to very quickly. The first is the decision of this court only last year in Iconics and Dream Pairs. It's at page 2513 of the bundle, and it covers the first 2 of these 3 propositions. The issue was whether Dream Pairs had infringed Iconics' marks.
But just pausing there, not in the context of what the court should do if satisfied that the judge below is wrong, but in the context of actually deciding whether it should
proceed.
Conclude that the judge below was wrong.
Yes.
In other words, it was addressing, albeit by reference to what you say is the same principle, a different problem.
Yes. Let me turn to that now, my Lord. The issue here is whether there's an infringement of trademarks by reason of the sign-on footwear by Dream Pairs being similar to the Umbro trademark that was owned by Iconics, such that there was likely to be confusion to the public. The Court of Appeal overturned the judge's conclusion, dismissing the claim. And as you see from the head note, reading just below letter F, the Court of Appeal held in particular the judge had erred in principle in his approach to the assessment of similarity. Then the Court of Appeal carries out the assessment itself. And we go to page 2517, and the heading at the top was the Court of Appeal entitled to remake the decision. Underneath that, in paragraph 93, this court first observes the question whether there's a trademark infringement. It's a classic example of a multifactorial assessment. And then at 94, reading just below letter D, while of course the decision of an appellate court trumps that of the court below, the law has imposed structured constraints designed to prevent a free-for-all in a higher court. Whenever a party with the necessary resources wishes to challenge the first instance decision of the trial judge, the reasons for these constraints are set out in a string of well-known authorities, including Fage and Jabani. And those reasons include the point at Roman 3 that in making his decisions, the trial judge will have regard to the whole of the sea of evidence, whereas an appellate court will only be island hopping. And then at 95, at the foot of the page, reading just below letter J, there's reference to a Court of Appeal judgment in the case of Sprint Room, 2019, where it was held that on a challenge to an evaluative decision of a first instance judge, the appeal court does not carry out the balancing exercise afresh, but must ask whether the decision of the judge was wrong in one of the ways identified. So I pause there. My Lord, that is therefore a clear authority that where you have this sort of evaluation, a multifactorial assessment before you, even if you find that there has been an error of approach on the part of the court below, the question whether the appellate court at that point is entitled to remake the decision is a matter that it should approach with great caution because of the structured constraints applicable in this field and because of the points made and quoted from Lord Justice Lewison in Fage. You please turn up the second authority, and that's at page 2464 of the bundle. It's the Privy Council decision in Chin and Chin. The issue here is a dispute about beneficial ownership of the shares in a company after a marital breakdown. The judge mistakenly decides that he doesn't have to deal with the question whether the parties intended that Mrs. Chin would be a joint owner of the company with her husband. That's paragraph 9 on page 2467. And then page 2468, paragraph 13, the Court of Appeal on the appeal goes to the other extreme. They give a detailed judgment of their own on the issue, assessing the documentary material before them. And at paragraph 14, the Privy Council notes the absence of factual findings made at the trial. The relevant statement of the law is at the top of page 2469. The normal and proper function of an appellate court's review. An appellate court can, within recognised parameters, correct factual findings made below, but where the necessary factual findings haven't been made below and the material on which to make those findings is absent, an appellate court ought not, except perhaps with the consent of the parties, itself embark on the fact-finding exercise. It should remit. And the shape and content of the remittal directed in that case is set out at paragraphs 17 and 18. The Privy Council expresses the view in 17 it's advisable the rehearing should go to a different judge. And in paragraph 18, the Privy Council outlines the 3 critical issues to be specifically redressed on a remittal in that case. So it's an example of focusing the remittal that should take place. How do these propositions apply to this case? Point 1, the FRAND determination here is a multifactorial assessment by the court. It includes the need to make findings of primary fact by the judge, and then to carry out an evaluation in the light of the full evidential record. These findings of fact include, among other things, findings about the features and the circumstances of negotiations, of other licenses which are potential comparables, and to the extent the data allows, whether those licenses are good or less good. The evaluation of the facts includes, for example, what information can I get from these past licenses? How can it be used to gauge a FRAND rate in the case before me? It also includes consideration of the implications of a proposed FRAND rate, my ground 2. In this case, even on the premise that the Court of Appeal was absolutely right to conclude, A, that the judge was essentially unreasonable in treating the Apple licenses as competitively negotiated with other people able to look after themselves, and B, that the judge erred in principle in his evaluation by using an inclusive averaging approach instead of searching for best comparables. They, in my submission, were not in the position themselves justly to undertake their own evaluation. And based on what I've covered so far, I'll simply give you a few brief examples. On the footing that the judge erred in principle by not following the right approach of looking for the best comparables, the Apple licenses should have been assessed individually. And even if they all were artificially depressed, take that as the premise, looking at them in that way would help you decide by how much that was true. But instead, the Court of Appeal here uses all the Apple licenses, it takes the top of them, as the lower bound for its range. And you've seen it doesn't have a basis for assessing whether a point in the range above it is too far or too close to these Apple licenses to be FRAND, although that is exactly what it proceeds to attempt. And now consider the Google license, which formed the upper bound of the initial range. Optis says in its written case, paragraph 160b it was the judge who decided the Google license was a useful comparable. It was the judge, it wasn't the Court of Appeal. But he did not. He did not decide that individually this was a useful comparable. Indeed, he made the finding that when unpacked, it also disclosed a royalty rate which he called indefensibly high. If I may just give you that reference, it's page 592 of the bundle, near the foot of the page. Right at the end, just above letter C. It's the last two words of letter C. Page 592. It was only the Court of Appeal that used the Google license individually in the way you've seen. The Court of Appeal did not hear the evidence at trial about it. It did not see the cross-examination. But in the last sentence of paragraph 143 of its judgment, page 311 of the bundle, the Court of Appeal evaluates that one of its possible FRAND points is unacceptable because it is, in its words, too far from Google. It has made no necessary findings to enable it to make such an evaluation, and it refers to none. And finally, consider the commercial impact of the Court of Appeal's own determination in the marketplace. It purports to carry out a cross-check to see if the commercial consequences of its new 15-cent rate per unit are acceptable. And as I say, it applies it not just to Apple phones, but a differently priced Google phone. But apart from stating boldly the percentage of selling price of two phones that this $40 amounts to, without any comment, there is nothing. There's certainly nothing that the industry could see as a meaningful cross-check that this is commercially workable. And for those reasons, in summary, I say, even if the Court of Appeal had been right to find the judge erred in principle in his approach to the evaluation, what it should have done is to remit.
Do you say that, did the Court of Appeal have before it the material on which to make factual findings?
It did not, no.
Well, I think it'd be helpful for us to have a note in writing of what material the Court of Appeal actually had.
Yes, certainly do that. As I mentioned earlier this morning, I think I gave you...
You gave examples about how few pages of the transcript they had. They didn't have the witness statements. They only didn't have the witness statements. They only had certain documents.
Yes.
And so forth.
Yes. So I can tell you what they did have, and I can certainly put that in the note.
Yeah. And I suppose what they didn't have.
And also, yes.
But rather than just do that generally, it would be helpful to focus it on the key key aspects of the evidence so far as their analysis was concerned.
Yeah, because every case has a vast trial bundle of which most of the documents turn out not
of which the Court of Appeal is usually most
looked at. So just saying the number in the trial bundle and the number it doesn't tell you very much.
My Lord, you're right. So it leads, I don't know if I have time for this, in 2 pages, to the separate question of how this court should dispose of this appeal if we're right. We say the answer will depend on the way in which, if we're right, the appeal is upheld, very simply. Because if this court accepts our case that the Court of Appeal was wrong to find the judge fell into error in the inclusive averaging approach, let us say, and he acted reasonably in working with lump sums from the existing license agreements. The first possibility is that this court feels able to accept that the only material error it needs to be concerned with is the judge's error in including the cuckoo in the nest, the Optis Google license. Stripping out that license and recalculating the average is a computational matter. But if there are points raised before this court in this hearing, which you regard as being matters regarding reconsideration, the approach should be that any remittal should be as tightly focused as possible to concentrate on resolving those particular issues. And in this regard, there's a group of 4 points, essentially, which Optis has articulated in a notice of intention to participate, which we understand to be the respondent's notice points in this court. But the grounds for those 4 points were not then developed or even discussed in Optis's written case, despite this being the requirement in Practice Direction 512, and for obvious reasons. These points you find in the bundle on page 897, go straight to them. There are 4 points in paragraph 3, page 897. And those are matters that were raised by Optis as part of its appeal to the Court of Appeal, which the Court of Appeal said it didn't find it necessary to resolve, given that it was going to overturn the judge entirely. They are in the nature of attacks on aspects of how the judge implemented his methodology, and, the last of them, on changes he made between the draft judgment, the embargo draft, and the final judgment. Strictly, therefore, these aren't different or additional grounds for upholding the Court of Appeal's order. What they are is consequential points which arise if this court upholds Apple's appeal. And as I say, Optis did not develop those as required in its written case. It did not set out the grounds for these contentions in the party's case. In the circumstances, our understanding is that these points are not live. If my learned friend in his address says they are, despite not setting out the grounds in his written case to give us fair warning, then he will need to convince you that he should be permitted to advance them nonetheless. If and insofar as he is permitted to advance those respondents' notice points via his oral address in this hearing, I will have to deal with them as succinctly as I can in reply. The shape of any remittal standing back will then be something which necessarily this court will need to revisit in the light of that exchange and the hearing as a whole. So, my lords, I apologise for going 5 minutes over. Those are my submissions, other than on the final ground.
Yes. Very well. Well, in that case, we'll look forward to hearing you on ground 4 tomorrow morning at 10:30.